Does he have to set up the camera? Oh, there he is. Oh, yeah, there he is. Well, yeah, if you give them to me, I'll make sure she gets them. Good morning. Welcome to part 2 of How to Run a Family Law Trial. Today we're going to have a pretty exciting program. As you see from the agenda, later on in the morning we're going to have a trial demonstration with some of the top lawyers here in Toronto, and it should be very interesting. We're going to have real live witnesses, and I think you'll learn and benefit from seeing how senior lawyers in Toronto prepare for trial and see how a trial actually takes place. Now, this morning we're going to have a few lectures, very short lectures, and have the honor of having Chief Justice Heather Smith here today. She's agreed to come to speak to us briefly with respect to opening statements and what judges expect from family law counsel at trial. And as you know, Chief Justice Smith became Chief Justice in 2002, and before then she was our Associate Chief Justice. So I ask you to give a warm applause to welcome her today. And Chief Justice Smith.
Thank you. I would like to thank the organizers of this skills program for the invitation to speak to you today. I have been asked to speak about the decorum and civility that judges expect of lawyers in a family law trial. I suppose the simple answer to what a judge expects from counsel in terms of civility and decorum in a family law trial would be the same as what a judge would expect from counsel in any trial. Judges expect that counsel will treat the court with candor, fairness, and courtesy. Judges expect counsel to assist in maintaining the dignity and decorum of the courtroom and their profession, and to avoid disorder and disruption. Similarly, counsel are entitled to expect judges to treat everyone before the courts with appropriate courtesy. Now, I know that these concepts of civility and professionalism are not unfamiliar to you, but I think it's worthwhile speaking about why they are relevant and the joint responsibility both judges and lawyers share in ensuring that the administration of justice is not diminished in the eyes of the public it serves. I suggest the necessity for civility is relevant to lawyers, particularly advocates, because they are the living examples and thus teachers, every day, in every case, in every courtroom, and their worst conduct will be emulated perhaps more readily than their best. Civility is relevant to judges as well. Every judge must remember that no matter what the provocation, the judicial response must be the judicious response, and that no one more surely sets the tone and pattern for courtroom conduct than the trial judge. As Mr. Justice Watt of the Superior Court of Justice once said, and I quote, "Civility is not confined to the conduct of counsel. It is the exclusive currency in which all participants in the proceedings should trade. It is not a matter of judicial entitlement, a divine right of judges, so to speak. Civility is a shared responsibility. Judges who claim its benefit must also share its burden. Its beneficiaries must be its benefactors. Those who talk the talk must also walk the walk." End of quote. It may seem strange to some that such obvious truths as these need to be stated at all. But perhaps our failure to state them more often and practice them more faithfully has brought us to the need to discuss so simple and elementary a subject as the necessity for civility and decorum in the affairs of people, and especially people of the law. I am sure some of you are aware of the issue of decorum and civility in the courts is now an issue of great concern not only to judges, but to the legal profession in general in the province. The legal profession in Ontario has recently given considerable attention to what has been described as a crisis in professionalism and a loss of civility among lawyers. Mr. Ronald Slatt observed and I quote, "We as council are increasingly experiencing and talking about the decline among us of what has become known as civility. Practice in this hurly-burly world is not without its challenges. Council owe multiple duties in the course of practice, including obligations to clients, to opposing counsel, to the court, and to the administration of justice generally. It is often difficult to reconcile competing interests and obligations." End of quote. In understanding what is of concern, one must appreciate that the terms professionalism and civility, though not synonymous, overlap in meaning. Civility is an important component of professionalism, but professionalism clearly involves much more than civility. In the legal profession, civility is the act of treating other people with courtesy, dignity, and kindness. Professionalism, however, in reaching beyond the obvious desirability and limitations of good manners, encompasses the need for a shareable ethical and philosophical framework that will motivate and guide lawyers to be thoughtful, principled, and community-minded legal practitioners. The movement towards professionalism within a legal community creates the need for a shared standard or vision of what is meant to practice law effectively, ethically, and honorably. Mr. Justice Colin Campbell of the Superior Court of Justice perhaps best put his finger on the nub of the problem when he stated, I quote, "The changes that have taken place in the legal profession in the last decade or so to some extent reflect those in society as a whole, where competition and other pressures are reflected in a lack of civility. In order for the system as a whole to survive, all of us have to ensure that the growing phenomena of road rage on our highways is not reflected in adversarial rage in our courtrooms." End of quote. Mr. Justice Campbell's comments imply that if we are to evaluate the conduct of lawyers fairly, we should pay heed to the social and cultural context in which lawyers now operate. Contemporary Canadian culture is fast-paced. It differs from the culture of bygone years. Logically, then, one may assume that the culture of the legal profession has changed through the increasing size, the anonymity of the bar, through the undeniable influences of technology on the pace of modern legal practice, and a variety of other influences, in ways that may require careful attention if we are to maintain the integrity and moral mandate of the legal profession as a self-governing community. In the fall of 2000, the Law Society of Upper Canada established the Chief Justice of Ontario's Advisory Committee on Professionalism for the purpose of studying the perceived crisis in professionalism and the visible loss of civility in the practice of law. This Advisory Committee on Professionalism was constructed as a cooperative venture between the judiciary, the Law Society of Upper Canada, Ontario's law schools, and other legal organizations. The committee's proposed new understanding of professionalism for lawyers has been published as an article entitled "Defining Professionalism." This article appears on the Law Society's website, and members of the legal profession have been invited to comment on the proposed definition. In defining professionalism, the Advisory Committee seeks not only to clarify the meaning and interrelationship of professionalism and civility, but also to fashion a new creed for members of the legal profession. The Advisory Committee states, "Professionalism is revealed in an individual's attitude and approach to his or her occupation, and is commonly characterized by intelligence, integrity, maturity, and thoughtfulness." The committee contends that while there is an expectation, both among lawyers and members of the public, that lawyers will conduct themselves professionally, many people now feel that lawyers have forsaken their professional roots and see law more as a business than a calling. The committee speaks of the building blocks of professionalism, which collectively ought to define what professionalism means to lawyers. These building blocks include scholarship, integrity, honor, leadership, independence, pride, spirit, collegiality, service, and balanced commercialism. The final sentence of defining professionalism in the article, though, bestows special prominence upon the concept of public service. Professionalism, and I quote, "gains substance and utility when linked to a lawyer's understanding of the legal profession's role in society and when exercised in service to the public." The implication of such a statement is unmistakable. the loss of professionalism among lawyers occurs when lawyers forget society's expectations of an efficient and effective justice system, and when lawyers fail to remember that they are first and foremost servants of the public rather than warriors or hired guns. Like the Law Society of Upper Canada, the Advocate Society too has been hard at work attempting to improve the level of civility and professionalism among Ontario's lawyers. To that end, the Advocate Society has produced a pamphlet entitled Principles of Civility for Advocates. It articulates core principles of civil conduct for both lawyers and judges. This pamphlet is inspirational in nature. It is, quote, not intended as a code of professional conduct subject to enforcement by discipline or other sanction, but as an educational tool for the encouragement and maintenance of civility in our justice system. The pamphlet's preamble focuses on the significance of civility as a value. And I quote again, civility among those entrusted with the administration of justice is central to its effectiveness and to the public's confidence in that system. Civility ensures matters before the courts are resolved in an orderly way, and it helps preserve the role of counsel in the justice system as an honorable one. The Chief Justice of Ontario, the Honorable Roy McMurtry, in his introduction to the pamphlet, emphasizes the link between civility and professionalism. The level of civility at the bar directly relates to the level of professionalism of the legal profession, said the Chief Justice. The authors of the pamphlet attempt to explain this link in its preamble when they contend that civility is inherent in effective, vigorous advocacy. The preamble states as follows: litigation, whether before a court or tribunal, is not a tea party. Counsel are bound to rigorously advance their client's case fairly and honorably. Accordingly, counsel's role is openly and necessarily partisan, and nothing which follows is intended to undermine those principles. But counsel can disagree, even rigorously, without being disagreeable. Whether among counsel or before the courts, antagonistic or acrimonious behavior is not conducive to effective advocacy. Rather, civility is the hallmark of our best counsel. The point that is made in the preamble is clear, and it is a message that I want to leave you with today. Good manners and rigorous advocacy are not incompatible. Indeed, the hallmark of good advocacy is civility. Never forget that at the end of the day, the purpose of advocacy is to persuade the tribunal of the correctness of your position. Very few successful advocates are able to do so in a manner that is rude or discourteous. On the contrary, our greatest advocates have been renowned for their courtesy. A former Chief Justice of Canada, the Right Honourable John R. Cartwright, the Right Honourable John Cartwright, has been described as having the characteristics of fairness, reasonableness, candor, magnanimity, and complete integrity. He has also been described as the most effective counsel of his era. A former Chief Justice of the United States has written in a similar vein, and I quote, "There are some lawyers who scoff at the idea that manners and etiquette form any part of the necessary equipment of the courtroom advocate. Yet if one were to undertake a list of the truly great advocates of the last 100 years, I suggest one would find a common denominator. They were all intensely individualistic, but each was a lawyer for whom courtroom manners were a key weapon in his arsenal, or her arsenal. Whether engaged in the destruction of adverse witnesses or undermining, damaging evidence, or in final argument, the performance was characterized by coolness, poise, graphic clarity, without shouting or ranting, without baiting witnesses, opponents, or the judge." End of quote. The value of civility and courtesy in advocacy should never be underestimated. Belligerent and discourteous behavior of lawyers in the eyes of judges is not persuasive. Simply put, it is bad advocacy. Experience has taught that belligerent behavior on the part of counsel is frequently emulated by clients, and almost always to their mutual disadvantage. In the highly provocative professional pursuit of trial advocacy, self-discipline is essential and an effective tool in any successful lawyer's arsenal. So what relevance does all this have for lawyers such as yourselves who practice in the area of family law? Well, just this. Family litigation is often emotional for reasons that are obvious. The issues litigated are frequently very personal and often engender passions that lawyers don't experience in other areas of litigation. In addition, it's not unusual for there to exist a certain enmity between the parties that clients may wish their counsel to reflect when dealing with an opposing party's lawyer or witnesses. If confronted with such a situation, my strong advice is to remember that you are not mouthpieces for your client, and civility must never be regarded as a sign of weakness. The traditional imperatives of fearless advocacy and single-minded dedication to the interests of the client do not presume unwarranted aggression and belligerence. In the professional advocate, incivility is replaced with resolution, dedication, tenacity, and perseverance. Courtesy, respect, and civility are not only consistent with the single-minded representation of the client, but they complement it. Disrespectful, uncivil, and discourteous behavior by lawyers contributes to the public's disdain for the profession as a whole. Reaching for the lowest common denominator in behavior contributes to this. Young lawyers should seize the opportunity to improve their image through their own behavior as lawyers and as professionals. The decision a new member of the bar makes early in a career as to how to act professionally will have as much of a long-term impact on personal success and happiness as any other important professional decision. The legal profession is unique among the learned professions. In the wisdom of those who centuries ago gave us the common law, lawyers are at once colleagues and adversaries. Medical doctors, for example, do not perform surgery in such a manner that one physician attempts to undermine the work of another. But lawyers advocate in a contentious arena for the vindication of a particular party, recognizing that the quest to obtain justice for one, in fact, preserves the rights of all. Lawyers must ever be mindful that when they advocate the causes of their clients, they need not rely upon conduct that is lacking in civility or courtesy of any sort. Our common law tradition does not require it, our ethical canons do not suggest it, and our system of justice should not tolerate it. So, the renaissance of civility and decorum in trial advocacy can begin with days like today. Thank you.
Thank you very much, Chief Justice Smith. Our next speaker is Justice John Jennings, who will be speaking to us about best practices before the bench. His a resume of his past involvement in CLE is in your material, so I will not take too much time to introduce, other than the fact that he is past president of the Advocate Society. Justice Jennings.
One of the sole benefits of the aging process is that audiences tend to seem younger. And as a result of that, I'm emboldened to explain my presence here by reference to an old bromide, which hopefully the majority of you haven't heard. I refer, of course, to the immortal words pronounced by Mark Antony when, having stolen through the dark Egyptian night, beshrouding the desert north of Thebes, he came to the tent of Cleopatra. And on lifting the flap, he said, and I'm going to translate into English here for those of you whose Latin perhaps is a tad rusty. Upon lifting the flap, he said the obvious, "Madam, I did not come here to speak." To which she replied, and of course this is irrelevant to the point I'm trying to make, but for completeness' sake I'll give it to you, to which she replied, "Sir, we are not inclined to listen." I tell you that because the invitation that I got to join this august company was that I was to come along and critique the performances of former colleagues of mine as they examined and cross-examined. Now that's a wonderful opportunity. It requires no work, and you get to get your own back in an atmosphere in which the persons you critique have no opportunity to shoot back. So I accepted with alacrity. Somewhat later, quite a lot later, I got another letter saying, "No, now what you're going to do is you're going to speak for 15 minutes on what a judge expects from counsel at a family law trial." That's a snappy little topic. And I at first was prepared to say, "No, that's it, game over, unfair, I'm out of here." On reflection, I thought I wouldn't do that because it hit on a note that I have been trying to play for some years, and I think I'm supported in this by some of my colleagues. And it was touched upon by the Chief Justice, and that is that what a judge expects from a lawyer in a family law case is precisely what a judge expects from counsel in any piece of civil litigation. It doesn't matter, by the way, that I received a third letter which changed the topic again, because I'm not going to speak to that topic. I'm going to speak to the expectation topic. There is, I think, a myth out there that counsel in a family law trial requires different skills than counsel in a normal civil trial or in another kind of civil trial. And I urge you to accept my statement that nothing could be further from the truth. You guys who work in the trenches as counsel, trial counsel in family law cases will know that you require perhaps another layer of expertise above counsel in negligence cases, particularly in the skills of client management. But sometimes, perhaps your pursuit of those other skills leads you away from the basic tools of any advocate's armory. The tools of cross-examination, examination in chief, the tools of evidentiary knowledge, the tools of when to object and when not to object, all of the basic skills that any advocate requires in pursuit of the goal of advocacy, which, as we all know, is persuasion, must be mastered by the family law lawyer, or the family law lawyer has no business going into the courtroom at all. So I leave you with the opening message that if you ignore those skills, and you obviously aren't because you're here in a skills teaching program, if you ignore those skills, if you think you can get away with, well, look, parens patriae in the best interest of the child, to answer any question from the bench, forget it. You're going to get cleaned by an experienced counsel on the other side. At the risk of repeating, what we expect from you is really two things: competence and assistance. Competence, I submit to you, is the natural product of counsel who has followed the golden rule summarized by the 3 Ps: preparation, preparation, preparation. You can break that down, as I will in the next 10 minutes that are left to me, into self-preparation, preparation of witnesses, and preparation of the court. Let me start with self-preparation. Assuming that you're up to speed on the basics that I've mentioned to you, including the really important basic of how to lead in an exciting and entrancing way so that the trier of fact follows every word, viva voce evidence. You'll be hearing more on that today, but everybody talks about the skills of cross-examination. To my mind, the more important skill is getting the story out properly and easily, far more important than the devastating cross-examination that virtually never happens. But the next skill, obviously, is learning when and how to cross-examine, and when is important. You don't cross-examine just because you've got the chance to do so. You have to say, hey, am I going to get hurt here? If I'm not going to get hurt, can I get some advantage? And then you decide to cross-examine. And the same with re-examination. You make that decision. If I go in there and ask a question, is the hole that has been dug by my witness just going to get deeper? Am I better to move on and forget it, or can I do some rehabilitation? And the skills of excluding evidence. The skills of keeping evidence that your opponent wants to get before the court out because they offend an evidentiary rule that you will have anticipated in advance. So that's the first step in the self-preservation checklist. The second step, and I hope I'm saying things that are already trite, but I'm going to do it anyway. The second checklist is that after that final case conference or settlement conference, when you know you're for the high jump and this thing's going to trial, You have to sit down with yourself quietly for half an hour and do a last check analysis. What's left in this lawsuit that began like this and is now like this? What's left to try? Make a list of the remaining issues. Make a list beside them of how you're going to prove those issues. And beside that, make a list of the witnesses that are going to come along and assist you in that, or the documents upon which you're going to rely, so that you've blocked out on one piece of paper precisely what it is you've got to do and how it is you're going to do it. And then that will help you in doing two things: preparing your opening statement, about which I'll have a bit to say, and preparing your witness list. And the last area I want to talk about on self-preparation is, what do I call it? Personal preparation. A basic rule: if you've got a 10-day trial, clear your calendar. I mean, you are not going back to meet other clients at night. You are not going to too many darn good cocktail parties during the course of this trial. You will be working, and you'll be working hard. And it is a disservice to you and to your client, I suggest, to try and juggle too many balls. For that 10-day trial, you're focused on the 10-day trial. The other thing, and I'm almost embarrassed to say it, I can remember sitting there when a treasurer of the Law Society, I was in the bar ed course, and treasurer of the Law Society, who was an eminent counsel, came forward to give us a lecture on the skills of advocacy. And the first words out of his mouth were, "You got to make sure you have clean tabs." And I thought, oh, God. Well, now that I've switched and gone over to the other side, there's something in that. Take a look at your regalia. Make sure you're not missing 3 buttons in the middle of the vest. Make sure the gown fits and the thing isn't torn off the back. And make sure you got clean shirts. Patronizing, I know, demeaning, I'm sure. But if you're sitting up there and you're watching the gap in the vest and wondering when the last button's going to go, your mind isn't on what's being said. Come back to the basics. You're trying to persuade. You don't persuade. You don't look confident. You don't look in control if you look sloppy. So check out the regalia. And the last thing on the personal preparation is find out who the judge is. I mean, don't go in there in the morning and say, oh, it's Mr. Justice Smithers, and mispronounce the name. Get a hold of the registrar, find out who's sitting, and do a little inquiring. Maybe get online and see what cases have come down recently and what the ranges the judge seems to like are. Maybe find out if the judge is a stickler for evidentiary rules. Ask around. Moving over to preparation of witnesses, the first remarks apply, in my view, to all witnesses. It is absolutely, quintessentially important, fundamentally important, that you review with them prior to trial everything you expect them to say. I don't mean you give them a script, because that's fatal. You give them a script and they chant, or they sound like they're repeating something. You don't want that. But you do want that witness to know precisely the evidence he or she is supposed to give, and you can only do that by leading them through an examination in chief. I used to find it helpful to explain where the witness fits into the theory of your case, why the witness is important, make the witness feel important, explain to the witness that it's a very significant thing that the witness is being asked to do. If you have time, at least explain what a cross-examination is, but if you have time, have the witness cross-examined, either by yourself or by somebody else in your office. I'm obviously not talking about the 2-day assessment of a spousal support trial. I'm talking about a significant trial where credibility is an issue and you've got significant issues to try. But help the witness by exposing the witness to cross-examination. Another basic, but remember, your witness is going to be excluded probably from the courtroom by an exclusionary order, and the witness probably hasn't seen a courtroom. So if you can't do it yourself, have somebody from the firm take the witness or a bunch of the witnesses up and say, here's the courtroom, that's where the judge is going to sit, here's where you're going to give your evidence. Anything you can do to make the witness feel comfortable on that pretty awful day when for the first time in his or her life he has to go into a witness box and swear to tell the truth and give evidence. Anything you can do to gentle that situation down is to your advantage. Lastly, tell the witness what you expect by way of dress and demeanor. I don't mean to lay down a dress code, but it might be helpful if the witness is always turned up with a baseball cap turned on backwards when he comes to see it. It suggests that the cap at least be turned on frontwards or maybe taken off or something like that, because you can explain it this way. You've got a funny old judge and you want the witness to be liked by that judge. So the line I used to use, but I'm not sure it works anymore, is dress as if you were going to church. Anyway, that gives you the idea of what I think would be helpful. With your client in preparation, with your client witness, it is absolutely fundamental that you take this witness through the steps of his or her testimony by posing questions similar to the questions you're going to be using at trial. And if it doesn't happen once correctly, do it again. Woodshedding is permissible. What is not permissible is to say, this is the answer I want, tell me this, but woodshedding so that the client understands where you're going and the responses you're expecting is absolutely critical to the success of your case. Elliot Pepper, who's no longer with us sadly, but was one of the leading family law lawyers in this province 10, 15 years ago, always personally escorted his client to the courtroom. Preferably when a trial was going on, but certainly by himself to the courtroom with his client went Ellie Pepper in that introductory process, which I say to you is of fundamental importance. The worst thing that can happen to you is to have two things that can happen to you that are terrible. One is to have the judge think you've never met the witness before, and that's really bad if it's your client. And the other is to have that person freeze on you and dry up. And what you're doing by introducing the witness, the client witness to the milieu, is to try to avoid that problem. And lastly, explain the rules of cross-examination to your client, who may think you've abandoned him or her when cross-examination begins and there's a recess. Just make it clear you can't talk to them. Once cross-examination stops, they're on their own. And similarly, you can't talk to them if you're going to ask them questions in re-examination. They're on their own. Now, lastly, in the 2 minutes that are left, I think, I'll go to preparation for the court. There are two fundamentals, and I'm sure you've heard them again and again, but they're worth repeating. The exhibit book and the book of authorities. The exhibit book is the greatest device I know of to manage paper and simplify things for the triers. And if you do nothing else prior to trial, get an exhibit book. You'll get, I suspect, later today lectures on what goes into it, but I'll leave you with this general view. Make sure it's relevant and keep it simple. You don't want to dump 4 volumes on the trier's desk unless you absolutely have to, but put the relevant documents together in one place. Make a copy for the other side, make a copy for the court, and make a copy for the witness so the witness can follow along. Now, it's helpful but not essential to see if you can persuade the other side into a joint exhibit book, and if that works, fine. You need to do that about 3 weeks, no later than 3 weeks prior to trial. Make sure that all of the documents you both want are going to be before the court. And if you're doing that, it gives you an opportunity to say, look, can't we dispense with the formalities of proof here? Can't we agree that all of these documents may go into evidence without further proof, and they can be accepted as to the proof of their contents, or whatever it is the purpose that you're filing them for. So seek that consent if you're doing the joint exhibit book. If you're not doing a joint exhibit book, it doesn't hurt to send a copy over to your friend first and say, these are the documents I'll be filing. For the sake of expediency, do you require each one to be identified, or can we simply file them as one exhibit with tabs subdividing that exhibit at the outset of trial? The book of authorities, don't put it together at the end of the trial. This should be something you've got roughed out prior to trial beginning, and as issues change, perhaps you discard. But at the end, you should have a slim volume of the leading authority and perhaps one backup on the points that you wish to make on the court. I used to like to have it ready 3 days before the end of trial, if you could. And it doesn't hurt to say, to the court, my authorities are ready, and if it would be of any assistance, I'll file them with you now. And of course, if the other fellow hasn't done that, then you've got recess reading going for the next 3 or 4 days of the cases you're going to be relying on. Helps the trier really see where you're going, and can be very persuasive. Don't be afraid to file a book of authorities at the outset of the trial if you have it ready at that time. The last matter on preparation for the court is have yourself an evidence, I'm never sure how to pronounce this word, primer or primer, but you should have a trial book that you take to every trial into which you put the leading cases that you may need to recall, like that when somebody says that's hearsay and you're trying to show that it's not, or when something under a rule arises that requires some evidentiary authority, particularly when dealing with expert witnesses. So have that book at your side throughout the trial and put into it prior to trial the cases you anticipate may be of help to you in any evidentiary problems that you think are going to arise. Well, I said there were 2 things. There's competence. If you follow those rules, you're going to be super confident, I expect. And there's assistance. Assistance is particularly important when the presiding judge is not a core family law judge. I know some of you come from jurisdictions where there's a sitting family court, and one can expect that those judges develop enormous expertise. And there are other areas where judges rotate. The judge is going to rely on you to ensure that he or she has from you an accurate statement of the law that you have found and that applies to the facts that you have proved. And if you don't meet that expectation, I'm sorry to tell you, the word gets out. So remember, you're not dealing with a rocket scientist when you're dealing with a judge of the court. You're dealing with somebody who's doing his or her best to be a judge, but they will not have the immediate familiarity with the law and rule changes that you will have or ought to have as daily workers in that vineyard. So make it easy for the judge by finding and laying out for the judge the law. The words that I still remember that came to me from my principal when I was articled, he was a counselor who'd had vast experience. He only did counsel work and no solicitor's work. He was trained on both sides of the ocean. And his fundamental point was, John, remember that counsel's first obligation is to prevent the judge from making a mistake, prevent the judge from falling into error. It's your job to ensure that the judge gets it right. If you do that, if you keep the judge on the rails, I can tell you that your name will be hallowed in those halls where judges tend to congregate. I hope the rest of the conference works as well as the program suggests it will, and thank you for this opportunity to speak to you this morning.
Thank you, Your Honor, for those insightful comments on what we can do and what judges expect, and what we can do about making sure we meet the judges' expectations. Good morning, everybody. My name is Francine Shurkin, and I'm here to give you some short comments on how to prepare a witness for trial. In the materials that you have, there are some pointers on how to prepare yourself before you're preparing the witness, and also on which order to call your witnesses in. I'm going to confine my remarks to the preparation of the witness. When you go to court, it's important not only for you to look good, and that means for you to be prepared, but it's also your job, and crucial for an effective trial, for you to make your witness look good, which means that your witness has to be prepared. Almost everybody wants to do a good job, and that includes your witnesses. Your witness will be nervous, and they're going to be usually particularly nervous that the opposing counsel is going to make them look bad, make them look like they're not telling the truth, even when they know they are telling the truth. So I like to start off my interviews by telling the witness the key to being a really good witness. And it's twofold. One is be prepared. Two is tell the truth. I realize it's not necessarily in that order, but it's surprising how difficult it is to get all of the truth out in a straightforward and honest way when you're not prepared. There are 10 points that I'd like to cover today, and the first is, how do you get your witness, what do you tell your witness to be prepared? In this regard, the most important thing that a witness can do is to read every statement, everything that is attributed to that witness. So if the witness is, for example, your client, there may be an examination for discovery or the questioning transcript. They need to read that before their interview with you and again before trial and be familiar with it. There'll be affidavits, there may be letters, there may be witness statements, there may be other statements of things that are attributed to that witness. They need to be familiar with that. Not only will that help prepare the witness for giving evidence, you can be sure that that witness is going to be cross-examined on the statements or transcripts with respect to their evidence. Point number 2. Meet your witness. Now, of course, that goes without saying for your client, but it should be you, if you're doing the trial, who meets with every witness that you're going to call. This allows there to be some kind of rapport and familiarity for your witness and yourself, and that will help the witness. But it's also important in helping you, because then you have an idea of who your witness is, what their strengths are, and what their limitations are. In that regard, as an overstatement of an example, it brings to mind a story that Gary Stortini once told me. Gary is a senior member of the criminal defense bar, but at that time he was a young Crown attorney, and he was telling me about his experience in his first ever murder trial, which he was very excited about. So he called in what he understood from the police investigators to be his prime Crown witness so that he could go over that witness's evidence and they could meet each other, etc., and he could get an idea. The witness came in, and the gentleman was a little bit nervous, and he said to Gary, I'm nervous here, I've never done this before, I think I might need a little something to fortify me. Is that okay with you? So Gary said, well, what kind of witness is this going to be when he's just speaking with me? He needs some fortification. How's he going to do under cross-examination? But not wanting to alienate his witness right off the bat, he says, okay, sure. And then Gary understood the limitations of his witness when the gentleman reached inside his coat pocket, pulled out a bottle of Aquavelva aftershave, and took a swig. Point number 3, procedure. For most people, tell your witness about the procedure in court. For most people, when they testify, it will be a novel experience. They will be nervous, and the best way to put a witness at ease is to explain the process to them, as His Honor pointed out. Explain what's happening, what number witness will they be. Explain to them when they go into court about the taking of the oath or the affirmation, when they're asked questions, that you will be asking the questions first, that the opposing counsel will be asking second, that you may or may not have questions on re-examination, that the judge may or may not have questions, which will then allow you and the other counsel to ask further questions arising from the questions that the judge has. They'll want to know what to call the judge. They'll want to know, who do they look at when they're speaking? And to that, my answer is always to the person who's asking the question. If I'm asking the question, look at me. If the judge is asking the question, look at the judge. And if the other lawyer is asking the question, look at the other lawyer. What should they wear? And as His Honor said, we used to say your Sunday best, whatever it is that is respectful to the court process. Now you're ready for the part where you get to the meat of it, which is the questions. And I generally tell people that there are, in family law, generally two kinds of questions. The general question, the background, which lets the judge know where they fit into the scheme of things, and also, because these are easy questions, lets the client be, or the witness be, in the stand and have some familiarity. These might be things perhaps like age, occupation, job history, how do you know one or both of the parties? And then you get to the reason why they're there, what's their story, what happened that they know about that's relevant. And here is the very important part for you, which is to organize the evidence that the witness is giving. What is their story, or what is their part of the story in the trial, in the issues? Before meeting with the witness, you already have a good idea of their knowledge of the facts. And so before they come in, I like to have a rough draft of the questions that I'm going to ask, and I tell them the questions and I run through it with them. You don't want the witness to be fumbling in the witness box. If they have some familiarity, they're less likely to do that. Also, you don't want to be in a position where you ask a question, but the witness doesn't understand your question. And so, whereas there are 5 points that they needed to get out, only 3 come out. Deal as well with the weak areas in chief, so that when it comes to cross-examination, you'll take some of the impact out. And for documents, tell the witness, and in your run-through, give the witness the documents, and in court, make sure you also give the witness the documents that they are either going to be relying on or be questioned about, and tell them to read it. It's not a memory game. When you've finished with this, the witness should have a really good idea of what you'll be asking and also of what he or she will be saying. Number 5, as His Honor mentioned, don't woodshed. You should and can help the witness with how to give evidence in the ways that I've just described, but you have to be careful. It's their story. You don't tell them what their evidence is. That's their job. Number 6, another important point to explain to the witness is that you can't ask leading questions in chief. It's also better if your questions are broad. For example, you may start with a tell me what happened when, or those kinds of questions. The important point is that the story unfolds from the witness and not from the lawyer. And now the story is told, and your witness is comfortable and prepared in telling his or her part of the story. So you move on to cross-examination, and you want to tell your client or your witness about cross-examination. First, it's a good idea for you to have considered, if you were opposing counsel, what part of the evidence would you want to attack? What part of the evidence would you hope that the witness is going to say certain things about, and explain that, review that with your witness so that when they are asked those questions, they'll be prepared and know how to deal with them. Point number 8, tell your witness about hearsay. They should be told that they cannot say that a fact is true because someone else told them. They can describe an incident and what they saw and heard if the incident is what is asked for. But you cannot say an incident occurred because someone else told you. Their answers are limited to what they saw or heard themselves, not what someone told them. This applies, of course, in both examination in chief and also in cross-examination. The 9th point, demeanor. The judge is assessing credibility. Instruct the witness, therefore, for no other reason, to be courteous to opposing counsel. Also, ensure the witness does not become counsel, that they don't object to questions that are asked, or that they don't ask questions. That's your job to ask questions, or opposing counsel's job. It's your job to object if the question is objectionable, even if that means the witness has to answer the same question 3 times. That sounds pretty trite, but it's surprising how many people start objecting or asking questions when they get heated on a witness stand. If any objection is made, instruct the witness that they should wait for it to be dealt with before proceeding with their evidence. If the witness forgets a question or doesn't understand, tell them it's no problem to ask for it to be repeated and to state that they don't understand. If they don't know an answer, say so, don't guess. However, if they do know the answer, they must answer the question. Speak loudly, don't cover your mouth so that people can understand what you say, and also speak slowly, which is something I have to tell myself all the time. There is a transcript. The evidence is transcribed, so they should wait for the end of the question before they start answering. And that's a good reason not only for the transcript, but also for the next very important matter in assessing credibility, and that is that the witness is responsive to the question. They should listen to the question, and that's what they should answer. One way a judge assesses credibility is whether a witness answers the questions asked or is evasive. You will certainly be unimpressive to a judge if you just, as a witness, want to get your story out and you don't listen to actually what's being questioned, especially if the question is coming from the judge. And then finally, you're now prepared, the witness is prepared, you both know what's going to be said and what's going to be asked. Finally, it's a good idea to ask your witness if they have any questions, if there's any matter, big or small, that is bothering them, so that you can get that dealt with and out of the way before they give their evidence so that they'll be comfortable. And now on for the show.
Trying to get Mr. Epstein out of the room while I prepare my witness, and he wants to stay. That's all. We won the first round. What we're going to do in the next 10 minutes, we only have 10 minutes, we're going to discuss 4 different points, and we're just looking around where can we best do this? Does this come off? Take this off. For those of you who don't know us, my name is Tom Bastido, and I practice family law here in Toronto. And this is Dr. Erwin Mikowski, who's been of great assistance to the legal profession over the last 20 years, more than 20, he says, and who does psychotherapy and custody and access assessments, and has been very kindly offered to participate in this program and many other ones. So what we're going to do in the next few minutes is we're going to assume that Dr. Bukowski and I have had quite a bit of preparation, and there's 4 points that we're going to try to make in the next few minutes, which all of you, in my view, should be sure that you review with your witness. And the first thing, Dr. Bukowski, we're going to talk about is your qualifications. And you're aware that this case deals with mood disorders?
Yes, I am.
And if you are asked about your qualifications and whether or not you have any special interests in mood disorders, could you talk a bit about that, please?
Well, certainly I'm going to make reference to the fact that as part of my training as a clinical psychologist, I was well trained in the assessment and treatment of a broad spectrum of mood disorders. I also completed a 4-month clinical internship on the adult outpatient psychiatry team at Kitchener-Waterloo Hospital, and certainly the preponderance of clients that I would have been engaged with suffered from depression and other forms of mood disorder.
And have you written or published or taken any special courses or been involved in any clinics dealing specifically with mood disorders?
I haven't published in the area, but as a part of my ongoing continuing education, I regularly attend programs sponsored by the Ontario Psychological Association, and over the years, certainly some of the seminars and workshops I've attended have dealt with mood disorders.
The reason we're discussing this is Dr. Bukowski's real curriculum vitae indicates clearly that he has no special expertise in mood disorders outside of the clinical expertise which he's trying to stress. So what we're doing is we're alerting him to the gap in his curriculum vitae and his qualifications upon which he likely will be cross-examined. I'm going to give you about 3 cases when I'm talking, and there's one case, a very recent case called Goulet, G-U-I-L-L-E-T, versus American Home Assurance, and that's 2003, 65 OR 3D 58. And in that case, there were 3 doctors giving evidence, and the judge decided the case almost entirely on the superior qualifications of one of the doctors. You have to understand that most judges haven't the slightest idea of what the experts are talking about, and just as a general basis, and therefore, the person with the higher qualifications gets some points out of the starting gate. Dr. Bukowski, in your dealings with Mrs. Brown, you developed quite a relationship with her.
I believe I have, yes.
And how would you describe your role? Are you a supporter of hers?
Well, certainly as her therapist for more than 2 years, I'm very supportive of her as a person, supportive of her view of the world and so forth. But at the same time, I recognize that as an expert witness, I also have a responsibility to the court And balancing those priorities is certainly a primary task in giving expert testimony, in my experience.
Now, the reason we're bringing up this is Dr. Butkowski is probably going to be attacked, or maybe be attacked, on the grounds that he has a vested interest in this patient of his, who is his patient, and he's here to give expert evidence. There is another case. You remember the basketball player's case in British Columbia, well-known case, called Van de Peer. It's 2004, Reports of Family Law, 5th series at page 436, a judgment of the British Columbia Court of Appeal, and in that case, the family physician's evidence was accepted over the evidence of the, and I don't say this pejoratively, hired psychiatrist, and it is a good case for showing that doctor finding in that case clearly stated that she had the interests of her patient at heart and that she was a supporter of the patient. But what Dr. Butkowski says about the duality of the dual fiduciary relationship he has to the court and the patient is a difficult one, and that brings us to the next point, which relates to notes, right?
Right.
Now, Dr. Butkowski and I had a big discussion about whether you'd bring your notes today. Is that correct?
That's right.
And Mr. Epstein wrote and asked for them.
Yes, he did.
And what is your concern about bringing your notes?
The kinds of records that I keep, to the extent that they're disclosed to one of my clients, has the potential for causing harm, psychological harm, to my client. And one of my ethical responsibilities, of course, is to protect my client and ensure her well-being. Primarily, I'm concerned about the potential damage to the therapeutic relationship and the trust within it, such that the disclosure of notes and records has the potential to render the therapeutic relationship ineffective. And I have had experiences, in fact, where I've been summoned to court, compelled to produce my notes and records, and subsequently the client has terminated service, probably by virtue of what the client heard and read in the notes and records. So in this particular instance, what I'm going to submit is that I've, in recognizing that my credibility in part bears on the database that I bring with me to support my evidence, that I have in fact taken the opportunity in recent therapy sessions to go over all my notes and records with my client in order to ensure that she understands the entries and that she would not suffer any irreparable harm, nor would the relationship be harmed by virtue of the disclosure of the information.
There's two cases here. One case is called Cook versus Ip. That's a case of the Ontario Court of Appeal. It's a 1985 case, 52 Ontario Report, 2nd series at page 289. There's a number of cases that follow it, several of which have been written by Justice Ellen MacDonald. Essentially, this case stands for the proposition that if you put a person's mental or emotional health in issue, then you in effect waive the privilege that attaches to it, and you must produce the doctor's notes. Now, there are some exceptions to that, and there was one suggestion we get into a long discussion today about the legalities of this, but I don't intend to do that. But in the Ryan case that Nicole Tellier mentioned yesterday, the issue in that case, or one of the issues, was the doctor had made notes to herself. Dr. Parfit had made notes to herself, and so there were two sets of notes. There were her general clinical notes and notes to herself. And I think you will find for a doctor like Dr. Butkowski, who is used to the turmoil of the courtroom and who deals with lawyers all the time, his notes are written in such a way, perhaps inadvertently, that
Sure.
they're inadvertently written that way. So that if the notes are brought into court, and Dr. Butkowski accurately stated that his evidence depends in large part upon the accuracy of his recollection, and no one can remember what happened 3 years ago at a meeting with a patient or a client. So I think the best advice is, if you are calling a doctor, look at the notes, and if there's a problem in the notes, don't call the doctor, if you can help it. Now, the last thing we're going to talk about, the fourth thing in the last 2 minutes, is the major depressive disorder. Now, there's a mistake in this fact situation, and Dr. Bukowski and I both brought our books today. This is the Diagnostic and Statistical Manual of Mental Disorders. It's the 4th edition. It's called DSM-4, which is the last one, -TR. It's essential if you're going to use this book, you use the up-to-date copy.
TR stands for text revision.
Text revisions, thank you. And they're continuing, this is sort of like the Oxford English Dictionary, they're continually revising it. Is that right?
Yep.
Yeah. And you have to make sure you get the latest one. Anyway, this book, for those of you who don't know, has various diagnostic indicia which must be attached to the description of what the diagnosis is. Is that correct?
Right.
Do you want to spend a couple of minutes dealing with that, and then we'll...
Yeah, I just want to mention as well that while DSM-4 is probably the most widely used internationally, there is another diagnostic manual called ICD-9, which is more often used in European countries, but sometimes referred to in the United States. So basically the evidence I'm going to be giving is that my client meets all of the criteria for a major affective disorder, and specifically in this instance a depression, which I'm going to describe as being chronic and of a particular type. The way you use the manual is typically to qualify for a particular disorder, you have to have some, you have to meet some but not necessarily all of the criteria that are listed. So it may tell you that the depressive episode has to have lasted at least 2 weeks, and you have to have at least 4 other of the major symptoms of depression. And my evidence in making this diagnosis will concern those issues. The other thing that's important to know is that it was not until the passage of the Regulated Health Professions Act that a psychologist was given the legal authority to engage in the controlled act of diagnosis. So officially I can make a diagnosis now, but when I started practicing I was not able to do so. Only a medical doctor was able to do so.
So what Dr. Bukowski and I would do after sketching out the sort of substance of what I've said this morning, we would then meet and go through the various indicia that he would use to support his diagnosis. We would discuss whether or not it was chronic, discuss the cross-examination, which will center on that, and also the what they call the course of the disorder. That is to say, is the course going to be run out or not? And we would look at the notes together. This is ordinary preparation. It's generally a good idea for the solicitor and the psychiatrist and psychologist not to get into an extended note-taking part at this time. We want to avoid those little problems. And Dr. Bukowski will clearly indicate on his cross-examination that he has met with me, that he's discussed the parameters of the case, and that the diagnosis, the notes, and the opinion are entirely his own. Correct?
Right.
Thank you very much.
So now we're going to be doing the trial demonstration. The facts are set out at tab 1 of your materials, and it'll summarize the facts scenario, which our actors and actresses will be showing in their trial demonstration. And the case summary report, which is attached, is Dr. Potowski's summary of his involvement with this, with the applicant, who is Susan Brown. And Susan Brown will be played by Laura Potty, and she'll be the first witness. So I would ask counsel to come up, along with Her Honor Justice Himmel is here. And we will move things.
Perhaps we should just say that this will take us 5 minutes. We need a 5-minute adjournment just to set up the chairs and things. Won't be any longer. goes right through, yes.
So why doesn't she? You're an example to the rest of us. Sure, yeah. I was really kicking myself. Yeah, so that's how I think it's supposed to be.
We're ready. Are we taking another break at 11?
Yes, Tom knows he's going to see a few words at that time.
Okay.
We have a break right after.
We have a break right after. Okay. I'm just running whether to run to the washroom now or I'll wait till then. That's okay. I'll wait till then.
Time, council forgets or time passes.
Close to 11? Okay. Okay. And Tom Bastido saying something?
Court is now in session. As council at tables, respective tables. Your honors are being asked for an order excluding witnesses, and I guess it's been granted. Mr. Badowski, Dr. Badowski.
Your Honor, Dr. Butkowski is an expert, and traditionally or typically experts are not excluded from the hearing in the ordinary course, and I don't see why Dr. Butkowski would be excluded from this hearing.
And what's your position?
I'm not surprised that Mr. Grant is reneging once again on an agreement that we made outside. But the focus, the important witness in this case is Dr. Butkowski, and there are legal and factual issues tied up in his examination. And in this case, it's appropriate to exclude Dr. Butkowski during opening statement because I should say both counsel are going to be trying to preview the very issues that are going to arise during Dr. Butkowski's examination and cross-examination. And for that reason, it's appropriate to, to keep the witness in a neutral state as an expert.
Well, I'm glad, Your Honor, that my friend recognizes not only Dr. Butkowski's preeminence, but the importance of the evidence that he will be giving in this proceeding. But I'm content with that to leave Dr. Butkowski out. That's fine.
All right, that's fine. So there'll be an order excluding witnesses.
Your Honor, I act for Susan Brown, and as you heard, my friend Ms. Hannaford acts for Paul Brown. The parties were married for about 14 years before Mr. Brown left the matrimonial home to take up residence with his friend with whom he had been having a long-term relationship. You will hear evidence of that. The parties have two children, Marie, who is now 13, and Joey, who is now 9, and fortunately the parties have been very sensible and reasonable and have resolved custody and access so that they are not in issue in this proceeding. The parties have also, again, very reasonably resolved the child support issues, and you will see by minutes of settlement that they've agreed that Mr. Brown will be paying child support in accordance with the child support guidelines and agreed upon Section 7 expenses. Now, Your Honor, you will hear evidence that Mr. Brown is a senior analyst with the Ontario government. Fortunately, his employment was not affected by the change in government in the recent election. He earns approximately $120,000 a year. My client, Susan Brown, has not worked outside of the home since, apart from doing volunteer work, since their elder child, Marie, was born, as I said, about 13 years ago. Now, Your Honor, there are really two major issues in dispute in this proceeding. And I mentioned a moment ago the circumstances surrounding Mr. Brown's leaving the home. As a result of that and other factors, you will hear that my client Susan Brown is suffering from a major depressive episode or disorder, and I will not say anything more about that. You'll hear much evidence about that, and that is the reference that my friend Ms. Hannaford made when she mentioned Dr. Butkowski's evidence in this proceeding. You'll hear evidence about that, but that leads us to the first issue that Your Honor has to decide, and that is spousal support. We will be seeking long-term, indefinite, significant spousal support, again, with no termination date. The second issue is this, and again, this really is a commendation of the parties and their reasonableness. The parties have resolved all property issues except for one, and that issue has to do with Mr. Brown's pension through his employment. And the singular issue having to do with Mr. Brown's pension is his expected date of retirement. You will hear, in my view, cogent and compelling evidence that Mr. Brown intends to and always intended to retire at the earliest possible retirement date available to him, which in his case was age 55. So having said that, to recap the issues, as I say, are spousal support, which I, on behalf of Susan Brown, which we are claiming, and the remaining property issue having to do with Mr. Brown's pension. Those are the issues before Your Honor in this trial. Thank you very much.
Thank you. Ms. Hannaford?
Thank you, Your Honor. As Mr. Grant quite rightly indicated, there are two issues that we bring to the court today for resolution. The first, of course, being spousal support. The second being the factual question. We're asking the court to determine the age at which Mr. Brown would likely retire. Properly framed, the questions really in our submission for the court are, one, what is the structure of spousal support that will best achieve the objectives for support contained in the Divorce Act? And two, of course, what is the age that Mr. Brown would reasonably and likely retire for the purposes of pension valuation? Just for Your Honor's information, the differential between the value of the pension at early retirement and the value of the pension at normal retirement is $155,000. The effect of that, of course, is that if Your Honors determine that the pension is an early retirement pension value, namely that Mr. Brown would likely retire at 55, the equalization difference is $77,500. And it's our submission that the evidence as it will evolve in this trial will coalesce around two questions, namely, what are the economic disadvantages suffered by Ms. Brown? And two, how can the court, through its discretion, promote Ms. Brown's self-sufficiency? Now, the evolution of that, the problems that we have with resolving those questions unfold against a backdrop of facts. And Mr. Grant has offered a narrative related to the demise of the marriage. But I want to just outline those facts which are not in dispute and which do form the backdrop and the context for the unfolding of these questions. One, Susan Brown worked full-time in the charitable sector up until 1992. After she stopped work in the charitable sector, earning $30,000 per annum, she continued to participate in that charitable sector where she was employed right up until the separation on a volunteer basis. Two, while she was working, and there is no dispute about this, Ms. Brown was energetic, committed, devoted, and successful in her career. And of course, that's evidenced by the fact that she continued in the volunteer sector, in the charitable sector. Three, the two children, Joey and Marie, aged 9 and 11, are healthy, well-adjusted, doing well in school, and are attached to both their parents. That is also not in dispute. 4, Susan Brown, like Paul Brown, is a loving, devoted, energetic, and committed parent, and that is not in dispute, and indeed that's the foundation upon which the parenting plan, whereby Ms. Brown will have primary residence of the children, is built. 5, the marriage foundered in approximately 2001, and Paul Brown did leave the matrimonial home in May 2001. That is not in dispute. And 6, the demise of the marriage was traumatic, a traumatic event for Susan Brown. That is also not in dispute. The focus of the spousal support dispute evolves out of the traumatic effect on Susan Brown of the demise of the marriage. And the question to which the examinations and cross-examinations will be devoted, and what you will hear, is a focus on the extent of the depression that impedes Ms. Brown from achieving self-sufficiency. And you will hear, we anticipate, debate and discussion around the issue of just how Ms. Brown is impeded from obtaining self-sufficiency. The witnesses you will hear from are witnesses who are being called by Mr. Grant and, of course, his associates, his colleagues, Mr. Bastido and Ms. Tellier, namely Susan Brown and Dr. Irwin Butkowski. The case for Mr. Brown is being called through cross-examination by my juniors, Mr. Epstein and Mr. Niman. And with that, Your Honor, we are prepared to proceed.
Thank you. I think what we're doing is we're going to hear the various examinations, and then at the end, we're going to give a commentary on the opening statement, all the examinations, and then I'll do the closing statement as well. So I guess we'll move on then to the next part, which is the examination in chief.
Pardon me?
Okay, we're set. I understand that you are Ms. Susan Brown,
Yes, I am.
and that you were married in May 29th to be exact, 1987.
Yes, I was.
That you are 44 years old, and that you have been living separate and apart from your husband since May of 2001. Is that all correct, Ms. Brown?
Yes, it is.
And you have two children, aged 11 and 9, Maria and Joey.
Yes.
And I understand as well that you have been to see Dr. Carolyn Franks, your family physician,
Yes, I have.
and you've been to see Dr. George Brown, a psychiatrist,
Yes,
and you've also been referred to Dr. Budkowski. Is all that correct?
it is.
And I understand you saw Dr. Budkowski first in about mid-May to late May of 2001.
Yes, that's correct.
And you are married. You were married to Mr. Paul Brown.
Yes.
Now, with those sort of facts and preliminaries out of the way, perhaps we could ask you to look backwards, if we can, to May or April of 2001. And as you reflect upon that time period, could you tell me a little bit about how you viewed your marriage at that time, please?
I thought everything was okay. We'd had some stressful periods in our marriage, but everyone does, and I really felt that everything was okay. Excuse me, I loved my husband, and I'd given up my career to look after my children, and my family was the #1 priority in my life.
When you say you'd given up your career, was that a decision that you made, or was there anyone else involved in that decision?
My husband and I decided when our first child was born that I would stay home and look after the children. So I guess in answer to your question, it was a joint decision.
And can you remember after that decision was made any discussions about that decision at all from that time until today?
We talked about it a few times, but it was always the decision that I would continue to stay home, and I've done that.
Now, you said that your marriage had been under some stress, but no more than perhaps most. What happened on that day in May? Do you remember the day in May, May the 1st?
Yes, I do.
What happened?
My husband just didn't come home from work that day.
Really?
Excuse me, yes. And
You all right?
excuse me, I'm losing my voice, sorry. That day I felt like the rug had been pulled out from underneath me. Everything was just gone all of a sudden. So.
And again, looking back, after, as you put it, the rug had been pulled out from under you, how did that affect you?
I just completely shut down. I couldn't do anything anymore. I didn't know what to do with myself. I couldn't get out of bed. I couldn't eat. I couldn't sleep at night. Even though I was sort of sleeping all the time, I never really felt like I was getting any rest, and I was waking up all the time. I started to lose weight. I couldn't look after my children. My mother had to come and help me look after my children. It was pretty bad. It was very bad.
And how long did this sort of episode last?
It still continues, really. I don't feel like I have recovered from that. I can't seem to get over it. So it's continuing today.
Now, I understand that you have been working with Dr. Budkowski.
Yes.
And have you discussed some of these problems with him from time to time?
Yes, yes.
How has your situation varied at all in the last year or two?
Varied?
In terms of how you've been feeling?
No, not really. Sometimes it gets worse, but it's pretty bad all the time. I find it really tough to cope with day-to-day life. What used to take me 10 minutes takes me 2 hours now. Like just even getting up in the morning and brushing my hair, or taking the kids to school. I can't seem to do that. I've had to hire a housekeeper to help me. Making decisions like whether to put my daughter in figure skating or ballet has just become impossible for me.
Really?
Yeah.
And can you remember, you said that the stress varied from time to time. can you remember what happened in, if anything, in September of 2002?
Yes, that's, I do recall actually, that was when I was watching television and my husband was, I was watching the news and my husband was being interviewed. He was receiving an award and he was, he had his secretary whom he's now living with him, and he was thanking her for all her support and talking about how she was his life partner and how you know, she was everything to him, et cetera, et cetera. And at that point, things just really seemed to, I was just floored by that. You know, all the years that I'd spent supporting him just seemed to be nothing to him. So.
And how did you feel about your own self-esteem?
Well, it's been really difficult because my marriage was everything. I had given everything I had to that. So at this point, I really feel very worthless, and I don't really know what I'm supposed to do with my life.
And have your friends been supportive?
They were at first, but that support is starting to run thin.
Why would that be?
I think they're getting tired of me complaining all the time and not being able to do things with them, not being able to go out and socialize, or even my mother has told me, you know, that she's starting to get tired of my constant negative moods and attitude.
Now, as you know, one of the issues in this case is about the position, as I understand it, of your husband, that you should immediately go out and get full-time employment at some productive job. What is your general attitude towards that possibility?
I would love to be able to go out and work. I'd like to be a productive member of society, but I just don't know how I can do that. I tried to take a course and couldn't get the assignments done. I had to drop out because I just couldn't do it. I couldn't make it to class. I couldn't get the work done. I couldn't get the readings done.
Couldn't you?
No, I just couldn't. Just even getting, as I said, even getting out of bed in a day is very difficult for me.
And is it pretty well even all the time? Have you noticed some improvement since you first started seeing Dr. Butkowski?
Well, the medication has helped a little bit, but again, I still feel very, I don't feel like I'm better by any means. It's a very difficult thing for me. It's been a devastating experience, and I don't know yet how I'm going to get over it.
And how physically do you feel?
I suffer from a lot of headaches and backache, neck and shoulder problems. I'm not as active as I used to be. I don't feel like I can go skating or cycling or hiking like I used to enjoy doing with my children.
And how is your energy level, if I can put it that way?
It's very low. As I said, I feel like I'm sleeping all the time, but I'm not getting any rest. I sleep sort of waking up all the time, and then at night I can't seem to get to sleep, but then in the daytime I can't seem to get out of bed. I have a lot of problems with sleeping and rest.
Now, I'd like to change the topic just for a minute or two with respect to, and this goes back a long way in your marriage, but it relates to the retirement of your husband.
Yes.
Do you remember any discussions about his retirement?
Yeah, we used to talk about it a lot, about how he wanted to retire early, I think at age 55. And I remember one time in particular, I just remember it because it was when my daughter had just started kindergarten, and my husband and I, we never used to watch television together because he liked to watch sports and I just didn't enjoy that. But on that particular day, they had done a news report about my daughter's kindergarten school, and so we were watching that together, and just in the commercials there was a commercial about retirement funds, and I remember my husband saying at that time, you know, Freedom 55, that's what I want to do, that's
Really?
for me. So.
And in the exhibits, there's a page from what appears to be your husband's diary. Did he keep a diary?
I discovered that he did after he left. Yes, well, you actually asked me to just go through and find some information to fill out the financial
Yes.
forms. So I was looking through his papers and I found his diary, and I found a page in that diary where he talked about how he wanted to retire at 55, and he wanted to move to France with his secretary and run a bed and breakfast, which was, of course, a devastating thing for me to find.
Ms. Brown, just listen carefully, please, to this question. Is there any time in your entire marriage that he ever indicated to you that he wanted to retire at any age other than age 55?
No.
Thank you very much.
Cross-examination?
Thank you. It's a pretty gloomy day out today, Ms. Brown.
Yes, it is.
Probably doesn't help how you're feeling.
Oh, it doesn't.
Right. This evidence that you gave earlier today to the court, and in particular, this, I believe you described a situation where your husband was on television receiving an award.
Yes.
Was there any reason why that was never disclosed to us prior to this morning?
I don't know. I just recalled it recently, so
Right. And you found that very upsetting.
I did. It was devastating. He was.
Is it
thanking
fair to...
his-
I'm sorry?
I'm sorry. He was thanking his mistress for all her support over the years when I supported him.
And you found that upsetting, of course.
Devastating.
Right. Devastating. And angry?
Yes.
And it's fair to say that the circumstances involved in the separation between you and your husband were devastating to you?
Yes, they are still.
And resulted in you not being able to get out of bed, I think you indicated. Not being able to look after the children, you indicated.
Yes, I've
Right.
had to hire help.
Pardon me?
I've had to hire help to do that.
Well, you had your mother there first, and now you have some help.
Yes, yes.
And you weren't able to eat, you weren't able to sleep, you weren't able to look after the children. Is that your evidence?
Yes, it is.
And I believe that Mr. Bastido asked you whether that's continued without variation since that date. Do you remember him asking that question?
Yes, I do.
And do you remember you were having some difficulty understanding what he meant by variation? Do you remember that?
Yes, I think I was, yes.
But your answer ultimately was that it's basically been the same since separation. Is that right?
Yes, I think it was, yes.
So it's your evidence, and what you want this court to accept is that as a result of this separation, you have been in a state where you haven't been able to sleep, haven't been able to eat, and haven't been able to look after the children. Is that your evidence?
Well, yes, but I think the children are being looked after, and they are in my care. I'm not neglecting the children, but it's very difficult for me, and I've needed help.
Well, how is it that you're able to look after the children if you don't get out of bed and you can't participate in their activities with them, you don't eat? How is it that you're able to look after your children?
Well, I do eat, but it's hard for me to get myself to eat. I guess that's what I meant. I maybe should have clarified that a bit more. And I have lost a lot of weight, but I haven't completely stopped eating.
Now, just on the point that Mr. Bastido raised about this pension, you understand that there is as Ms. Hannaford said in her opening, were you here when Ms. Hannaford spoke?
No, I wasn't.
All right, well, Ms. Hannaford explained what the case for her client was. That's the purpose of an opening statement. And she explained to you, or rather not to you, but to the court, that there is a significant difference in the amount of money that will be payable to you depending upon when your husband retired. Do you understand that?
Yes, I do.
You stand to get a lot more money if the age of retirement was found by the court to be age 55 rather than 65. Am I right about that?
Yes, you are.
You understand that?
Yes, I do.
All right. And in your evidence, you indicated that, I guess it was upon the advice of Mr. Bastido, was it, that you started rummaging through my client's papers?
Well, I needed some information in order to fill out the forms. Since my husband had abandoned me and the family, we needed to seek support. So I was looking for financial information, yes.
All right. And did you find the financial information in the diary that you reviewed?
I don't recall. I don't recall where I ended up finding out the specific pieces of information that I needed.
Well, the evidence, as I understand it, is that you went through my client's diary. Is that fair?
Yes.
All right. And you didn't ask him, by the way, dear, can I go through your diary? Did you?
Well, no, he'd left.
Right. But you didn't call him up and say, by the way, your diary was left behind. Do you mind if I go through it?
No.
So you picked up the diary and you read through it, right?
Yes.
All right. And in that diary, you found a piece of paper that you ripped out. Is that right?
Yes.
And you gave that piece of paper to Mr. Bastido, correct?
Yes.
All right. Now, I just want to read to you what I understand that page to be. It says, "Another horrible, miserable day at the office. I can't wait until I retire. There is no way I am going a day longer than I have to. Then I can do what I have always wanted to do. I want to run a bed and breakfast in France with Sandra." Now, is that what was written on this piece of paper that you ripped out of the diary?
Yes.
All right, and you looked through the diary fairly carefully, right?
I believe so.
And did it appear to you that from time to time, during the time that you and your husband lived together, that your husband was feeling sad or unhappy?
I think from time to time, maybe. I don't recall any particular.
Pardon me?
I think from time to time, yes. But
Right.
I don't recall anything particular.
Right, but it's normal,
Extreme.
isn't it? Isn't it
Yes.
normal to, from time to feel unhappy or miserable?
Yes.
Right. And on that day, your husband seemed to be recording how he was feeling, right?
I guess so. I don't know.
All right, but in looking through that diary, there was other references to how my client was feeling at work, wasn't there?
I don't recall.
Well, let me help you with that. May I approach the witness, Your Honors?
Certainly.
Thank you. I'm showing to you an excerpt from the diary. Now, first of all, I'll give it to my friends. They can share it. Copy of that, and I'll give it to the court, a copy. Now, do you mind if I stand next to you?
No.
Okay. Maybe I'll hold it because you seem to be clutching that microphone. Now, is this in your husband's handwriting?
I think so, yes.
All right. And it is dated Monday, April 15th, 2001?
Yes.
And that occurred, when was the separation again?
May the 1st, I think, if I
Of
recall.
2001?
Yes, yeah.
So this notation was written in your husband's diary a couple of weeks before you separated?
Yes.
All right. So can you just hold it for a moment? And can you read that into the record for me, please?
Am feeling much happier today. Things are going very smoothly at work now, particularly since Mike Harris has resigned. This is good because I expect I will need to work until I am 65.
Keep reading.
I couldn't possibly retire any earlier, what with my financial responsibilities to Susan and the children.
Right. Can we have that document marked the next exhibit, please, Your Honor?
That'll be made an exhibit.
Thank you. Now, I guess you forgot to mention that when you were giving your evidence earlier today. Is that
Yes,
what it-
I did forget about that.
All right. Now, the fact of the matter is that Marie is 11,
Yes.
right? Joey's 9, and my client is 46. Is that right?
Yes.
And notwithstanding your difficulties in getting around at home, I take it you know how the children are doing at school?
I think yes.
Pardon me?
Yes, I do.
All right. So you keep generally aware of how the kids are progressing at school?
I try to. as best I can.
Right. And everybody's agreed that you are a fit and proper person to have custody of the children. Is that fair?
I don't think my husband has asked me for custody.
Right. He's agreed, in fact, that you have custody of the children.
Yes.
Now, tell me a bit about Marie. As I understand it, she's a very bright child.
Yes, she is.
She is what is colloquially referred to as a gifted child at school.
Yes.
And I understand from time to time that she has mentioned that she would like to be a doctor one day.
I think so, yes.
And by the way, just before I forget, speaking about doctors, how many doctors are you seeing?
I have 3, my family doctor, my psychiatrist, and my psychotherapist or psychologist.
Well, there's another one as well, isn't there? There's one that you're starting to see recently. Did you forget about that?
Oh, I'm sorry, I must have. Yes, there's a 4th.
There's a 4th one, Dr. Jones.
Oh, right, yes.
Isn't that right? That's how I understand the evidence to be. You're seeing Mary Jones, an internal medicine specialist.
Right. Sorry, yes.
So you're seeing 4 doctors.
Yes.
Must keep you very busy to be seeing 4 doctors.
Well, I don't see them every day, but I'm at the doctor's office fairly regularly, yes.
Right, okay, and so coming back to Marie, who would like to be a doctor, and Joey is 9, am I right about that?
Yes.
And you're seeking support for yourself for your lifetime, is that right?
Yes, at least until I can get better, which I don't know when that's going to be.
All right, so the reason why you're seeking support is because of your health problems, correct?
Yes.
All right. Were you healthy and well, you would go out and try to contribute your own support. Is that fair to say?
Yes, I would.
All right. So let me understand your evidence concerning my client's retirement. I want to understand that. You say that it was always understood between the two of you that he was going to retire at age 55. Is that right?
Yes.
And as I understand it, neither you nor your husband have invested in any of those university scholarship plans. Is that right?
No, we haven't.
Right. So I take it that, let me just do a quick calculation. My client, when he's 55, that's 9 years from now, correct? He's 46,
Yes,
and
yeah.
9 make 55. So in 9 years from now, Marie will be 20, is that right?
Yes.
And Joey is going to be 18.
Yes.
And I take it that you hope that both children go on to some post-secondary school education?
Yes.
Particularly if Marie has these aspirations. Does she go with you, by the way, to the doctor's office? Is that where she got this idea to be a doctor? Does she attend with you?
No, not usually, no.
All right, so she's come to this independently.
Yes.
All right. So in any event, both Marie and Joey are going to be in university, right?
Hopefully.
That's what your hope is. And so if Marie is 20 when my client is 55 and he has retired from his position, he won't be able to support Marie through university, will he?
Well, my husband is a civil servant, and I believe he has a fairly generous pension.
Right, so you're prepared to have that pension, whatever the amount of money is, be used to support the children through university and provide some support for you and for himself.
Well, I believe that was his plan, that when he was planning to retire at 55.
Right, and would you agree with me that his pension is going to be about half of what he's currently earning?
I'm asked to ask you to rise to observe a moment of silence for those who have sacrificed themselves for us.
I just have a couple of other very brief questions. I understand that you telephone Dr. Budkowski occasionally. Is that right?
Yes, I do.
And Dr. Budkowski has given you his home number. Is that right?
Yes, well, there have been times when I've been in quite a bit of crisis.
Right. So he's giving you that number to use in case of emergency. Is that right?
Yes.
And your depression that seemed to be connected to your separation, is that what happened?
Yeah.
And you were
the
going
humiliation
through
of...
Pardon me?
Sorry, the separation and the humiliation of my husband of 15 years moving in with his secretary and standing in front of all the world and...
May I continue? My time is running out, Ms. Brown, so I'll try and do this as quickly as I can. As a result of the separation, leave aside for a moment the humiliation, that was a process of grieving, is that fair to say, similar to any loss? Is that a fair observation to make?
Yeah, but...
Pardon me?
Yes, but so much more as well, I think.
Right, fair enough, fair enough. And most recently, you've been diagnosed with something called chronic fatigue syndrome.
Yes.
You're really tired, is that it?
Yes. I find it difficult to engage in any kind of prolonged activity and...
Right. You're really tired.
Yes, I'm quite tired.
Right. And I want to ask you a bit about your husband, Paul, and about this humiliation, how he's dealt with you. All right?
Mm-hmm.
Because it will be Paul's evidence. I want to give you a chance to respond to it now. I can tell you that Paul's going to give evidence about the fact that he's been entirely supportive of you since separation.
Well, I would have to disagree with that, but...
Well, that's why I'm asking you right now. So you won't agree that Mr. Brown, your husband, has been empathetic to the difficulties that you've been encountering?
No, I don't think he has.
All right. So let me ask you this. When you separated, you were suffering from a major depressive disorder. Is that right?
Yes, I still am.
Fair enough. But you were suffering from a major depressive disorder. You've described in some detail the difficulties that you were having getting out of bed, eating, participating in any activities with the children, needing your mother to come in, etc. Now, you'd agree with me that my client and the children are quite attached?
Yes.
And he loves his children?
I assume he does.
You can't
I would hope he
acknowledge that he
does.
does?
I don't know, but I think he does, yes.
All right. So he does love his children?
I think so.
And the children love him?
Yes.
Right. And notwithstanding the fact that you were suffering from this major depressive illness, you'd agree with me that my client took no steps to try to obtain custody of the children. Is that fair?
Yes.
And you'd agree with me that he has been financially supporting you since your separation without any court order? Correct?
Yes.
And you'd agree with me that he's not asked for the home to be sold? Correct?
Yes.
And you'd agree with me that even though he loves the cottage, that he has acceded to your request that he not use the cottage because you would find it to be too difficult for him to be at the cottage? Is that right?
Yes.
And he's paid for the housekeeper that's currently working for you, correct?
Yes.
All right. I think that my time is up, and I have no further questions of you. Thank you.
So we'll take a 15-minute break at this time, and
And for Laura Laura is one of Julie Hannaford's arting students, and she kindly came over here today. Thank you, Laura.
I'm sure she won't want to be a witness again.
Yeah, but I always, they do ask.